First case to come before the court is State versus Henry, and each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes.
I'll reserve 5 minutes, Your Honor.
That sounds good. You may proceed.
Thank you, Your Honor. May it please the court. My name is Neil Angle. I represent Michael Henry, the appellant in this matter. Your Honor, the facts of this case, as interesting as they are, there are just some straightforward issues that I've cited in my appellate brief. The first is the assignment of error related to the willful fleeing. My client had 3 encounters with the police that I spelled out in my brief. The state is arguing the conviction only came from the third contact. The first contact was just the officer was yelling at my client, please stop in the Metro Park. He said, I don't know if the client, Mr. Henry heard me or not. He got in his car, he left. The officer pursued him without lights, without siren, at a strip mall. He met my client and he said, hey, there's this accusation at the park. I want to talk to you. Mr. Henry denies it, said, I don't know anything what you're talking about, and he left. At that point, the officer pursued him, activated his lights and siren, and my client, within 200 yards, stopped the vehicle. And he was then charged and convicted of fleeing. Now, the jury here was only instructed you had to find that there was an audible signal and that you avoided it. 200 yards, Your Honor, is basically less than the length of this building. My client immediately pulled over, and that was the only conviction, and that was the only evidence that he willfully fled from the time that the siren was activated.
Well, there were numerous places he could have pulled over in that location, that area.
Well, that's not an evidence, Your Honor. We know it happened within 200 yards. We don't know if he heard the siren. We don't know how loud the siren was. We don't know how long the siren was.
Do we know how far behind the car?
No, that's not an evidence either. Like the distance between the police car and my... Right, we don't know that either. So is 200 yards reasonable? Is it a short distance? Is it excessive distance? There's no evidence that...
Well, that's going to be depending on the circumstances. And you're saying there's no evidence as to... in the briefs, everyone talked about where the location was, Merriman Road and Portage, but that wasn't in evidence?
That there are numerous places to pull over? No.
Well, not necessarily there's numerous places to pull over, but was there evidence that this was a commercial area?
No. And I mean, the officer didn't say he could have stopped in a much sooner manner. There was no evidence of that. And again, I would submit, Your Honor, the testimony of 200 yards is a very short amount of distance if you're driving 35, 40, 50 miles an hour. We don't...
In that area, it's not. This field is not that. 200 yards is 2 football field lengths.
Correct.
And in that area, which is, it's not, that's pretty far to go at 25, 35 miles. And he just left the parking lot. He had just left the parking lot, right?
He left, but we don't know how delayed before the officer pursued him, activated...
No evidence in the record about how long it took the officer to get in his car and follow him.
No, and that's not reflected. But I would argue based upon that, Your Honor, as you read the briefs, that this evidence, there's insufficient evidence. Now, the second assignment of error is a very interesting assignment of error. My client, he's charged with masturbation in a park, and he had on his pocket at the time of arrest 1 condom, and then he had a gym bag in his car that had like 2 additional condoms and petroleum jelly or cocoa butter. It's not very clear, but a jar of it. And they introduced this in evidence at his trial for public indecency. Now, the defense objected, saying it's irrelevant and it's more prejudicial than probative, and we are raising that, and the trial court overruled it. I would submit, Your Honor, the fact whether my client had a condom or not, whether he had petroleum jelly in a vehicle hundreds of yards away or not, is totally irrelevant to the public indecency. He didn't display it to anyone. He didn't show it. He didn't, other than having in his pocket the 1 condom, it didn't further the crime in any way. It's not linked to the crime in any way. The state didn't attempt to show that this condom petroleum jelly is in any way related to public indecency, but they're introducing it. Why? It's not relevant. It's only to show that my client is a bad guy, and that because of these evidence, he committed the public indecency. Now, the state in this brief says, well, condom and and petroleum jelly could be used in the manipulation of genitalia, and therefore it's admitted on that basis. But, one, the jury didn't have to make a finding of manipulation of genitalia, and two, anything in the world could be used under that theory in the manipulation of genitalia.
I guess I'm ignorant here, but I'm not sure I understand why having a condom either in your bag or on your person makes you a bad person.
Well,
Because you said it was only used to put him in a bad light, and I'm not sure how that puts him in a bad light.
well, if we take it by that, then what is the relevance of it? I mean, the state, it's irrelevant material evidence.
Well, and we only deal with prejudicial error. So
Correct.
that's what I'm getting
And
at.
the state, and when I argued it is more prejudicial than probative, the state, they're not even saying it's harmless error. They did not once raise in the reply brief, well, even if it was erroneously admitted, it's harmless. So they're not even themselves making the argument. The state, in its closing argument, referenced the fact that, well, he had condom and petroleum jelly in his car, ladies and gentlemen. I mean, so they're referencing the fact that he had this, that somehow because of this, he's some kind of sexual predator or some kind of pervert, that because of these, he's more likely to have engaged in showing his genitalia at the Metro Park.
They're saying it's more like having a syringe in your car instead of a heroin.
Correct, correct. And I'm saying, well, under the theory that it's used for manipulating genital, what if he had socks in his gym bag in his car? Is that can be placed over a penis? Are we going to say that's admissible to prove public indecency? The motor oil in a car? Is there anything on him, a pen, that could be used for manipulation of genitalia? Why don't we say, well, obviously he had a pen, ladies and gentlemen of jury. I mean, the absurdity of that argument has no end. Why was it introduced? If he would have displayed it or showed it or somehow used it, that's an argument. None of that happened. So the fact that he had it on him was the only evidence they introduced it for. Now, the next assignment of error is public indecency is a misdemeanor of the 4th degree, usually, unless masturbation is involved. Then it's still elevated from an M4 to an M3. The jury made no finding of masturbation. The judge in the journal entry did not reference masturbation, but was sentenced as an M3. Now, under the Pelfrey and McDonald case that I cited, the Supreme Court has said the only evidence you can look at for an enhancement is the jury verdict form. The jury verdict form did not list masturbation, and nor the code section for masturbation was listed for the public indecency. So on that grounds alone, it should be amended from an M3 back down to an M4. Now, Your Honor, as part of my client's sentencing, the trial judge also ordered he was to have no contact with all Metro Parks. Now, that's in other words of saying he is banished from public grounds in Ohio. That, we are arguing, is beyond the authority of a trial court. You cannot impose a banishment, especially when it comes to government property. And this court is held where somebody engaged in some behavior in a courtroom, and the trial judge said, well, you were banned from the courtroom, and this court said, you can't do that. What if it happened, what if he committed this act in the post office? Are we saying he can't go into a post office to conduct business? It happened in a courthouse, it happened at a police station, wherever it happened, a court can't authorize doesn't have the authority to tell a defendant that you are banished. Now, a banishment is different than a no contact, which as a part of community control sanction, you can impose a no contact order. However, we're not doing a no contact on a person. We're doing a no contact in a park. And it's not one park, it's all Metro Parks. Is it Metro, and it's unclear, is it all Metro Parks within the state of Ohio, in Summit County, Ohio, in Akron? We don't know. The Cleveland Zoo is called the Cleveland Metro Park Zoo. Are we saying he can't go to the Metro Park Zoo as part of his community control sanction? And you have to remember, it's not just a community control, he was also sent to jail, which has been stayed pending this appeal. So they're saying, well, it's only a community control, but he's also going, not to prison, but to jail for a period of the suspended time. So we would argue there's no law, there's no authority that would permit the banishment. And I raise the argument that it violates the Supreme Court's rule, Ohio Supreme Court rule on intrastate travel. Now, the state in its brief did not address that argument in any way, shape, or form. And in the prior case I cited, there was a person was banned from being in drug-related neighborhoods in the city of Cincinnati as part of a conviction, and the Supreme Court said, you can't do that. You can't ban people from traveling within the state of Ohio.
You're in your rebuttal time, too, if you'd like to say.
Oh, thank you, Your Honor. I will reserve the balance of my time. Thank you.
Thank you.
May it please the court, your honors, my name is Thomas D. Bound. I represent the city of Akron, the appellee in this case. I think that your honors, you should affirm the trial court's decision for a number of reasons. First, I want to address the issues that appellate counsel talked about. As to the Wolf Fleet, it is clear in the record that Lieutenant Schellenberger says it's another 200 yards. There's testimony that Mr. Henry was accelerating away, and that it was another 200 yards that Mr. Henry traveled before he stopped at that location. So I want to clarify that in the record. As to the issue of the evidence, the condom and the petroleum jelly, the condom was on his person. One of them was. There was one unwrapped condom on his person. And I can't recall from the record if defense counsel argued that this could be described as he's a proponent of safe sex. That's why he carries a condom. The bigger issue is a condom is used to place on male genitalia. He did expose his male genitalia to the victim, the prosecuting witness in this case. That could be used for a number of reasons. Without getting too graphic, perhaps he wanted to finish but not leave any evidence there. That's the reason the condom could be used. I believe it's wholly appropriate. I don't believe it's too prejudicial versus the probative value. If anything, perhaps it's harmless error, but I believe it was properly admitted evidence. Regarding the issue of the public indecency by masturbation as being a misdemeanor of the third degree, this court has held on a couple different occasions where the statute is explicit and divides it up into subsections, particularly Edwards and I believe the Randall's cases. The court must follow the will of the General Assembly to subdivide it. Now, public indecency is a broad statute. There are other statutes that way. Arson, for example, has many different levels. There's a misdemeanor of the first degree version that can be enhanced to a misdemeanor of the fourth degree version. There are other versions of arson that are different levels, but they're subdivided into each subsection. When somebody is convicted of that, you're sentenced on that specific subsection. That's exactly what we have here. Mr. Henry was charged by complaint in December of 2014, referenced this as a misdemeanor of the third degree. That is what he was convicted of. The jury was given the instruction about masturbation. He was found guilty of it, and thus it should remain a misdemeanor of the third degree. The Eford, I believe it's pronounced Eford case, kind of discusses that, and there is a distinction between an issue of whether it's an aggravating, enhancing fact or whether it just remains as the basic element as charged. In this case, this is a basic element as charged as a misdemeanor of the third degree. So I would hold with the prior court's decision in Edwards and Randall's that this should be a misdemeanor of the third degree. As to the banishment, this is a proper provision of community control. I believe the trial court was well in its rights to issue this opinion as to no contact with the metro parks. Could the court suddenly be held to a standard of you can't have contact where the place where there was a shoplifting that happened? No contact was serious. Could that somehow not be done because it's not a person? Could we say, well, you have been trespassing numerous times at the Chapel Hill Mall. Could that be ordered as a no contact order? I believe it should be permitted and should be allowed. Now, defense counsel references State versus Burnett, which is a little different procedural posture as opposed to this court. In that case, the court discussed and decided a separate motion to dismiss about the constitutionality of that statute, about loitering and being told you are trespassing if you don't come back. I believe it's a different type of situation versus here we are addressing an issue of plain error as to whether it's plain that the trial court erred in its sentence.
You say plain error because the defense attorney didn't object.
Correct. There was no objection made at the sentencing hearing. The trial court then had no opportunity or ability to correct any deficiencies or errors. As to the issue of, I know defense accounts cite State v. Builder, which this court decided. That was a situation in which the court sentenced somebody to a specific jail term. I believe it was a public indecency charge as a misdemeanor of the 4th degree. A 30-day jail sentence was given. Case is over, it's final. When it went to remand and it came back up as Akron v. Builder, it was a little different scenario. There was jail time suspended on the condition to follow through with certain requirements of the court. One of those was the no contact provision. I would ask this court to follow Akron v. Builder, which I believe was decided after State v. Builder, so I believe it is appropriate precedent for this court to follow. As to the issue of the cumulative error, I don't believe that this case rose to any issue of cumulative errors on a case that had 4 witnesses. I just don't believe it arises to that situation. If the court has no further questions for me.
Evidently not, so thank you.
Thank you. I would ask that you affirm the trial court decision. Thank you, Your Honor.
Thank you, Your Honor. May it please the court. Your Honor, just to address some of the arguments on the public indecency, the journal entry and the verdict forms only say a violation of 2907.09. It doesn't list subsection A3 or A4. The subdivision where it lists masturbation or not. So we don't.
But that wasn't the complaint.
It wasn't the complaint, but the Supreme Court has held, how do you determine what the jury found? You have to look only at the jury verdict form.
But that was the only thing they were charged with, wasn't it?
Who?
The jury. The jury was only charged, I'm sorry for using that way. The jury was only charged with the masturbation part of public indecency.
Yes.
That was in the jury instructions. So they couldn't have found anything else.
Yeah, they could have. They could have just found public indecency. They didn't have to find public indecency by masturbation. Because if the testimony was that he showed his penis for 4 or 5 seconds and then put it back, okay? Now that could, and he touched it. So we could say, yeah, that's a masturbation, that would fall. Or we can say it's not a masturbation. He just exposed it and then he put it back. That could just be public indecency by
But
itself.
were they charged with that? Were
No.
they charged with straight public indecency?
No.
As a lesser included offense?
No, they were not. But the jury only found the violation of the statute, not a subsection. So again, we're only looking at the jury verdict forms. How do we know which subsection the jury found? And if it's not the M3, it should be the M4. Now, one last point related to the condom. He had 1 condom in his pocket, and he had 2 condoms in a gym bag and Vaseline in a gym bag, and a car hundreds of yards away from where this incident occurred. So if we want to say the condom in his pocket is somehow relevant, what was the Vaseline or cocoa butter in the car for? If he had the lotion, if he had anything in that gym bag, is that fair game to be introduced for public indecency? What is the limiting principle the state is arguing here that could not be used in the manipulation of genitalia? Is not used, is not displayed, is not shown, they're legal to own, possess. So to say, well, it's all relevant. For what? How is it more probative or less probative public indecency? If he didn't have the condoms, couldn't he have still committed it? Absolutely. If he didn't have the cocoa butter. What is the nexus between these items and the offense? And I argue there is none, and it was highly prejudicial because like you were saying about the syringe, it was introduced to show that he's some kind of pervert by having these, and therefore he's more likely to be guilty. So with that, Your Honor, I'd ask the court to reverse the conviction for the reasons stated there.
Thank you.
Thank you.
The court will take the matter under advisement. A written opinion will be prepared and sent to each of you. And you can also look, obviously, on our website, where we release our cases electronically.
Thank you.